Good afternoon and good morning, everyone. My name is Jamin Chavda. I'm an attorney with Chugh LLP in the Atlanta, Georgia office. Thank you all for joining our webinar today. I hope you're all safe and well wherever you are. So as we have all seen, there have been many changes to the law that affect small and medium businesses. For example, the federal government is giving an extra $600 a week for 4 months to employees filing for unemployment benefits, in addition to their state benefits. The benefits period extended from 26 to 39 weeks. And prior to changes in the law, there was no obligation for an employer to provide paid sick leave. The benefit to the employers, though, is that it provides payroll tax credits for those employers, and the employees that are on paid sick leave get to stay at home for various reasons. The SBA has announced 2 programs that businesses are going to be affected in terms of payroll, the EIDL and the PPP, each of which has programs that allow for certain funds to be forgiven if used for payroll. PPP provides 8 weeks of payroll, and we've been assisting many clients with their applications, at least through Bank of America. I know that Wells Fargo has just recently mentioned this morning that they're capping their loans at 10 billion, but that might change. We'll see how that plays out later this week. We do have a webinar on Wednesday of this week that's exclusively going to discuss the PPP and EIDL loans. Also, certain larger businesses have a $5,000 payroll credit that they're receiving, and other loans at 2% interest from the federal government. There have been separate benefits to the hospitality and airline industry. Also on Friday, we have an immigration webinar that's going to discuss various immigration matters from the USCIS and the Department of Labor for various petitions and beneficiaries. But for today, let's focus on employment. That's why we're all here. We've assembled a great team of attorneys from our offices throughout the country. So we'll start with Vikram Subramaniam from our Santa Clara office. So Vikram, how does workers' compensation apply to employees that contract COVID-19?
First of all, thank you for that kind introduction, Jamin, and for hosting this webinar. Great to be here this afternoon. To answer that question, if an employee becomes infected as a result of their work, workers' compensation may likely apply. But we would also advise that you need to intermittently check with your local state workers' compensation agency, because many have not provided clear guidance as to this issue yet. However, we do know that in prior instances, such as with respect to valley fever, which is an infectious fungus, and instances of such as that, the workers' compensation state agency has approved claims in such respects. So we would expect that the local state workers' compensation agencies would take a similar approach with people who are infected with COVID-19 as a result of their workplace environment. The only question may be whether that employee contracted it in the workplace. This could be a significant issue down the road because, as we all know, it's a highly contagious infection that you could even get infected by grocery shopping. So the one issue we'd like to point out is, even if the workers' compensation state agency doesn't approve it as a workers' compensation claim, that doesn't mean the legal issue goes away. The employee may just end up suing in superior court for negligence or even wrongful death, which could end up being more expensive. The bottom line is we would highly encourage all employers to maintain active workers' compensation insurance coverage if and when this issue arises.
And as a business owner, if I have an employee that's diagnosed with COVID-19, should I tell everyone about it at the workplace?
The short answer is yes, you should advise other employees who could potentially have had contact with that employee about the possible exposure. However, there's a huge caveat that every employer needs to keep in mind, every HR department, and that's the HIPAA, and that's the Health Insurance Portability and Accountability Act. And that law specifically states that you cannot disclose the name of the affected employee, and must also take all possible steps to protect the confidentiality of that affected employee. The only alternative may be if the affected employee gives written permission that yes, you can disclose his or her name. But besides that, confidentiality needs to be maintained. Now, who should know about whether an employee has such an illness? What we recommend is every employer should designate someone in their company, specifically probably someone in the HR department that is on a need to know basis. So that person would be the person responsible with such knowledge, and also isolating employees to ensure safety in the workplace. That's the important thing too, safety in the workplace, because the employer still has a responsibility to provide a safe workplace pursuant to OSHA, which is Occupational Safety Health Act. Again, so this is a very contagious illness. So employer really needs to take some extraordinary efforts, or perhaps maybe needs to let the affected employee work remotely. The one caveat we can add is the employer does have the ability to disclose general information regarding the confirmed case to protect the non-diagnosed employees. But again, so long as the employer does not provide information that would make the identity of the infected employee apparent.
Got it. Thanks, Vikram. And then what should the business owners do if one of their employees does not want to work with another group or team or another employee out of fear of contracting COVID-19?
Well, the simple answer to this question is the employer needs to make a determination if this fear is based on legitimate factors. Now, we can all go on social media online. We know what the symptoms to COVID-19 looks like. So we need to create a strong distinction between what are legitimate factors and what would constitute discrimination. So the employer needs to look at that employee. If that employee comes from perhaps a country that, you know, people have that suspicion, then we need to draw that fine line. Again, are there legitimate symptoms being shown, or is this employee being discriminated against because of his ethnicity, perhaps? So that's really where the balance needs to be held. But again, if there are legitimate factors showing this person has the illness, then yes, everyone, the employer needs to have a responsibility to isolate that employee and make sure the other employees are not infected. Back to you, Jamin.
Thanks, Vikram. So obviously, if most of the companies throughout the globe are doing remote work currently. So Verduhi from our Los Angeles office, what should employers consider when they have non-exempt workers who are working remotely?
Thank you, Jamin. Good afternoon and good morning, everyone. It's my pleasure to speak about these matters on this webinar. So regardless if employees, non-exempt workers are working remotely or not, they are, as usual, paid for hours worked. So if, let's say, an employer was closed for some reason because of this COVID-19, or they didn't work, or the employee didn't work for a certain amount of hours during the day, then employee should not be paid. However, we should remember that if a non-exempt employee was scheduled to work full day, but they didn't due to employer's request, then they still need to be paid in full. Also, it is recommended that employers have some kind of a reporting system in place. It could be a paper format, that could be online system, but employees need to report their hours. And so they also need to report their meal and rest breaks, also overtime. Other than that, employers should also consider providing computers, phones, and other necessary items to employees to complete their work. Jamin?
So thanks, Verduhi, for that. And can you talk a little bit about reimbursement to employees that are working remotely?
Yes. different states have different laws, and so it is recommended that each employer looks at their state law about reimbursement requirements. In California, according to California law, employers need to reimburse necessary business expenses that are reasonable. So, for example, since employees are working from home, they will most probably need internet, computer, personal cell phone, notebooks, and so employers are required to reimburse those expenses, but of course to a reasonable extent, and if those are necessary business expenses. Back to you, Jamin.
Thanks, Dewey. So Human Yavi's attorney in our Santa Clara office. Human, how do we make sure that remote employees are in compliance with data security rules for the company?
Hey, Jamin, glad to be here. So, back before COVID became an issue, it was easy to control employees at the company level. You can unplug them, you can stop their access, but now people are at home and they're going to have access to confidential information outside the office. So this is extremely important for companies who are dealing with data privacy regulations, whether you're dealing with HIPAA, GDPR, CCPR. There's a handful of solutions. One of the obvious solutions is, of course, technical solutions, security software, hardware encryption. What's most important about these solutions is that you actually use them. Having them without using them is basically, we don't recommend that. So you need to be able to block access when necessary through the technical solutions. And you also need to train your employees to manage those technical solutions, and also employees who are going to be dealing with data that's going to be subject to some of these technical solutions. We recommend hiring expert outside individuals to come and train your team. You can record the trainings, make them available at a later time to your employees. And then throughout the process, you also want to document your security policy. You can include it in your employer handbook, or if you would prefer to have a standalone security policy during this COVID lockdown period, we're more than happy to help you draft those. Please reach out to us. There's also additional work you can do to make sure that your employees are subject to pretty tight NDAs, intellectual property assignment agreements. And generally, you want to take additional precautions to protect your trade secrets. Right now, it's a hyper-competitive marketplace, and if you are at all concerned about either your data or your competitive advantage in the market, reach out to us and we'll work with you to find a solution.
Thanks, Human. So can you talk a little bit about best practices in terms of terminating an employee remotely?
Yeah, absolutely. So again, these are issues that are becoming really relevant now because a lot of folks are working from home, and because there's a lot of new regulations about terminating employees, we really recommend that you reach out to us to make sure you're not violating those rules. And I think some of the other panelists here are going to talk about whether you can terminate certain employees given the current state of things. So first, make sure you're not going to violate the new rules that are in place. And after you've made that determination, you want to move forwards with termination. You're going to really want to prepare in advance for that termination. You want to coordinate with your IT team, prepare for cutting off access to the company's servers and systems. And then you also want to make sure that you're going to be in compliance with the state law regarding final paychecks. I mean, in California, the final paycheck is supposed to be given to the employee the day that they are terminated. So make sure you're following state law requirements for final pay periods. We recommend doing the termination via video call and communicating effectively the reason for the termination, whether it's underperformance or whether it has to do with economic hardship on the company side. And we also recommend possibly following up with the employee via email or mail to provide further documentation about the termination. And if that's something that you're a little bit feeling like insecure about sending out, reach out to one of our employment law attorneys. They'll help you craft something that is not going to, turn out to be problematic in the future. if you're going to give the employee severance or other benefits after termination, consider getting a mutual waiver to avoid future employment litigation. And again, that's something that we can help draft if you're interested in that. So if there are specific issues with specific employees relating to termination, we highly recommend reaching out to an employment law attorney.
Thanks, Iman. Appreciate that. Jumping back to Verdui regarding documentation. Verdui, what should businesses look out for in terms of providing documentation to their employees regarding the pandemic?
Thank you, Jamin. If an employee has COVID-19 or is exposed to COVID-19, the employee is entitled to file for state disability insurance. And employers should provide such employees with information about their rights, how to apply for disability insurance, and inform them about paid family leave benefits. It is also required to have a notice because we have this new law, FFCRA. It is also required to have a posted notice, which will again tell employees about their new rights, about this new leave, paid leave, and who qualifies for such leave. And such notice needs to be posted in a conspicuous place on the premises. Other than the requirement, we also highly recommend for employers to have posters around in their office as a reminder of good practices, how to prevent spreading the virus. It is recommended also to have a temporary policy or a memo in place about COVID-19, so that employees do not refer to their handbook, but rather would refer to this policy or memo during this period of time. And issues that need to be covered in this policy or in a memo could be, for example, which steps need to be taken to prevent the illness, or what should an employee do if they feel ill, or who should they contact at the company, and what steps should the management take if they have an employee who fell sick. Jamin?
Thanks, Verdui. So just to discuss paid leave in general, we've got Prema Radam from our New York and New Jersey offices. Prema, so what are the reasons an employee can take leave?
Thanks, Jamin, and hello, everyone. It's a pleasure to participate in this very informative webinar. So eligible employees can take leave for a qualifying need related to a public health emergency. A qualifying need in a public health emergency for purposes of this new law is limited to when an employee himself or herself is unable to work due to a federal, state, or local quarantine or isolation order related to COVID-19, or if an employee has been advised by a healthcare provider to self-quarantine related to COVID-19, whether there has been an possible exposure to COVID-19 or an international travel from one of the listed countries, or if the employee is experiencing COVID-19 symptoms and is seeking a medical diagnosis. Alternatively, an employee can also take leave if he or she is caring for an individual subject to a quarantine order or is in self-quarantine. Also, an employee can take leave if he or she is caring for a child whose school or place of care is closed, or if the childcare provider is not available for reasons related to COVID-19. Other than that, an employee can also take leave if he or she is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services. Back to you, Jamin.
Thanks, Prema. So Brinda Gandhi from our Los Angeles office, can you please talk to us about the new laws regarding sick leave and payroll tax credits for small employers?
Yes, Jamin, thank you. Hi, everyone. The government has passed recent paid sick leave and family laws for employers with less than 500 employees with credits to the employer on their payroll tax return every quarter. So just a note, independent contractors are not included in this count as employees. This law was enacted on March 18th, 2020, and will be effective starting April 2nd, 2020, and it will expire on December 31st, 2020. But employers are advised to comply with the new requirements immediately. The circumstances under which employers have to provide paid sick leave was already covered by Prema earlier, so I'm not going to repeat that. However, all employees are eligible to take paid sick leave, regardless of how long they've been employed by the employer. Now, how much does an employer have to pay a full-time and a part-time employee? Full-time employees are eligible to receive up to 80 hours of paid sick leave. Part-time employees are eligible to receive an average number of hours they work over a 2-week period. So in terms of a dollar value, it's $511 per day, capped at $5,110. There's an exception for employers with fewer than 50 employees who can demonstrate that providing such paid leave would jeopardize the viability of the business as a going concern. Back to you, Jamin.
Thanks, Brenda. Back to Prema. So a lot of our clients have employee handbooks or have state laws that discuss sick leave. So how does the FFCRA impact sick leave under the handbooks or state law?
Sure. It's very important for us to understand that this new emergency law does not impact the regularly applicable sick leave under the employment contracts, handbooks, state or federal law like the ADA or FMLA. The employers must take all these laws into consideration as before. Also, it is important to note that the total leave under the FMLA, including the leave under the new law, which we are now discussing, is limited to 12 weeks in total. Back to you, Jamin.
Great. So, and then what about the PTO? Can they use that prior to the FFCRA application, or do they have to, what's the theory behind that?
Oh, here, an employee affected by COVID-19 has the right to use paid emergency sick leave available under the new law, FFCRA, before using any PTO benefits, if any are available at all. An employer cannot require an employee to use the PTO first prior to receiving paid sick time under the new law. Jamin?
Thanks, Prema. Going back to Brenda, can you please talk about the second part of the FFCRA and the Emergency Paid Family Leave Act?
Yes, Jamin. So the new law requires employers to provide employees with leave to care for their child who's out of school or loss of childcare due to the COVID-19 state emergency. Employees are required to provide advance notice to employers whenever they can. And this leave can be taken consecutively with a paid sick leave whenever applicable. Back to you, Jamin.
And can you please tell us how much the employees would receive for that leave?
Yes, so each employee would receive about 12 weeks of this leave. 2 weeks would be paid by the employee by using their PTO and sick leave policy per the company's policy, and the remaining 10 weeks will be paid by the employer subject to reimbursement. Now, what is the dollar value of this amount? Each full-time employee is eligible to receive leave equal to 2/3 of the regular rate. And this amount is capped at $200 and total capped at $10,000 for this entire period. Back to you, Jamin.
Thanks, Brenda. So obviously the government wants everyone to maintain their workforce, but unfortunately some layoffs or furloughs or termination might be necessary based on the economic circumstances. So Chetna Kasam from our Reston, Virginia office, if you don't mind, can you tell us if the businesses are going to close, what happens to the non-exempt and exempt employees in terms of payroll?
Thank you, Jamin, and thank you to everyone here for joining us today. So as Varduhi had already mentioned before, as per the Federal Fair Labor Standards Act, non-exempt employees have to be paid only for the hours worked, meaning if the non-exempt employees miss an entire day's work because the employer is closed and the employer didn't require them to report to work, then the employer is generally under no obligation to pay them, unless the employer has promised otherwise. However, exempt employees, on the other hand, should be paid in full in any work week in which they perform work, regardless of the number of hours they worked. If, however, the employer company closes for one or more full work weeks and the exempt employees are asked to not perform work for a full work week, then the employer need not pay such exempt employees during such full week closures. Also, employers must keep in mind that checking mails on the phones may be considered working. Thank you, Jamin. Back to you.
Thanks, Jayda. So Min Luong from our Los Angeles office. There have been obviously state and local orders shutting down businesses. So since the government's asking us, the business owners, to do that, what can they do to save on payroll costs in the meantime?
Thank you, Jamin, and thank you everyone for being here. There are many big companies like Disney and General Motors that are cutting employees' salary. It's absolutely legal and a valid strategy to keep businesses afloat, but there are a few things that the employer needs to consider. First, if you are going to cut people's salary, you have to give them notice. The employee can't be surprised when they get their paycheck. Also, salary reduction can't be retroactive. Also, you can't cut people's salary for discriminatory reasons. For example, a company can't say all females working here will take 5% less on their salary. It can't be based on race or gender. It could be based on the amount people make. So you can say if all the employees who make more than 100,000 salaries will be cut by 5%. You have to be mindful of the minimum wage law. Obviously, you can't reduce someone's salary and have them work less than minimum wage. To save on payroll, the employer can also cut hours for hourly employees. If the employee is salary, it doesn't matter if you cut their hours in a work week, they're still entitled to their full salary each week. To save on payroll, employees can furlough employees. Furlough is temporary laying off the employee. And finally, to save on payroll costs, the employer can terminate employment altogether.
Great, thanks, man. And so depending on the state, I guess, can you, do you know if employees that are furloughed or laid off, will they receive unemployment benefits?
They will, but there are also other practical differences between laying off employees and furloughing employees. So furlough employees is temporary, and the employer may want to use this option, especially for highly trained staff. So this would save the employer costs to find somebody new, to retrain them, to hire new employees when the pandemic is over. Generally, furlough employees will still receive health insurance under the employee health plan, but this isn't always the case. The employer needs to check and negotiate with the healthcare provider. If health insurance is during the furlough period, COBRA would kick in and the employer must inform the employee, and it's up to the employee to have the option to sign up with COBRA. If health insurance is covered during the furlough period, the employer needs to consider how will the employee pay their portion of the health insurance, since it can't be deducted from their paycheck. It's important to note that employment is still at will, so furlough employees can still be laid off, and layoff or termination is more permanent. The employee has, there's no guarantee that the employer will get their job back. The employer will not be responsible for health insurance, and COBRA kicks in. And yes, layoff and furlough employees will receive unemployment benefits. The new law increased the amount of unemployment benefits. It increases the time that people will qualify for unemployment, and it increases the number of people who will qualify. So self-employee, independent contractors, freelancers, people who have been furloughed, or people who have been reduced to part-time are eligible for unemployment. So each state is different. Each state will get, there's a different cap for each state, but in addition to the state's benefits, the federal government will give $600 per week until July 31st. And you apply for the $600 the same way that you would apply for your state unemployment benefit. And lastly, the new law adds additional 13 weeks of unemployment. Thank you, Jamin.
Great. Thanks, Min. Going back to Verdui, can you please tell us about the WARN Act and how it applies to certain employers?
Thank you, Jamin. Absolutely. So under the WARN Act, covered employers must provide at least 60 days notice to employees in advance of a planned closing or mass layoff. And employers are covered if they have at least 75 employees. And a layoff is considered a mass layoff if at least 50 employees are being laid off during any 30-day period. So generally, the law requires a 60-day notice in advance. But according to the temporary order of California governor, such 60-day notice requirement right now is temporarily suspended. And the suspension was intended to permit employers to, act quickly in order to mitigate or prevent the spread of the virus. Other than the 60-day notice requirement, nothing else has changed. So nothing else is suspended by the executive order of the California governor. Therefore, each employer shall do a detailed analysis before such mass layoff to make sure that it stays in compliance with state and federal WARN Act requirements. Thank you, Jamin.
Thanks, Verdui. Thanks. And going back to Prema, can an employer terminate an employee if they cannot come to work because they have been diagnosed with COVID-19?
Under the current situation, these are extraordinary circumstances. As we all know, an employer is required to protect the employee's job and cannot be replaced while on qualifying paid sick leave due to COVID-19. The employee, however, must return to work as soon as the need for leave ends, even if the employee has not used up all the paid sick time available under the new act. It's also important to note that employers can offer a different position to the employee when the employee returns to work based on the business necessity. It's also important to remember that the employers are prohibited from discriminating or retaliating against any employee who takes paid leave under the new act or has filed a complaint or instituted a proceeding under or related to this new act. Back to you, Jamin.
Thank you, Prema. Obviously, we have a lot of business owners, tech companies, and just folks that have contracts that they've entered into. So there's a force majeure clause. Chetna, if you don't mind telling us about that and what businesses can do to protect themselves during this pandemic.
Sure, Jamin. Thank you again. So force majeure clauses are typically designed to free a party of their contractual obligations if an unforeseen event that is beyond that party's control causes any delay or an inability to fulfill the contractual terms. The coronavirus pandemic would most likely be classified as an unforeseen event outside of the party's control, thus excusing the performance under a force majeure clause. That being said, the fact that your contract contains a force majeure clause does not mean you automatically have the right to invoke relief. Rather, you will need to establish based on circumstances whether such an event of force majeure under your contract has occurred. Your force majeure clause almost certainly will not identify the COVID-19 virus by name, but it may specify events like pandemics, epidemics, or work stoppages that may enable you to argue that the outbreak constitutes one or more of the specified force majeure events. To effectively enforce the clause, a company or individual must show that it is impossible to perform the terms of the contract. They must also prove that non-performance was unforeseeable and out of the party's reasonable control. Thank you.
Thanks, Chetna. I think that's all we have in terms of our presentation. If any of the attendees want to ask any questions, please use the raise your hand feature on Zoom. You can chat it over to our team that's taking care of all the questions. So we've got one here that says, we're a staffing company, my client pays my employees and technically no loss to me. Can I use the PPP for my employees? So that's a good question. We've got a lot of, that's a tech company scenario, obviously. So that's probably a better question answered on Wednesday by the accounting folks. But as long as in terms of the application, the banks have been asking for certain payroll data minimally, but basically it's been going back to the 2019 tax returns. So if you can show that there's payroll loss to you, then likely yes. But you know, in terms of adhering to what the application requires and the SBA terms are, I would recommend staying within the boundaries of that. Sasha, do we have other questions coming up here?
Please feel free to raise your hand if you have any questions. You can ask them live. You can also enter them into the chat box if that's more comfortable.
Let me, while we're doing that, Human, what have you seen in the last little while in terms of clients in the Bay Area asking for, in terms of their employee base, you know, with the work from home, or you know, just in general about terminating employees? What's been the trend there in the Bay Area?
Yeah, so great question. Couple things happening here. Obviously, we've been working with a lot of companies who are either laying off folks or they're furloughing folks. And unfortunately, that's just in order to survive as a business. But what we're also seeing is we're seeing companies realize that they don't have to employ employees anymore, and now they can start actually qualifying some of the workers as contractors, because of the degree of control is changing, right? So the rules in California have a lot to do with how much control you have over your employees, or your workers, whether they're employees or contractors. And as you lose that control, because either they're working remotely or you're not able to monitor their work, you may start to be able to categorize them more as independent contractors. So we're seeing a slight uptick in hiring of independent contractors and more, you know, service agreements coming out. But everybody's kind of bracing tight right now, just holding for a couple months. We're seeing brick and mortar getting hit really hard. Anything brick and mortar, I mean, is seeing massive layoffs. But on the flip side, you know, a lot of our tech clients are plowing through, they're working hard, and they're adapting.
Great, thanks. There's another question that came through. I'm gonna send this over to Prema. Is the updated sick leave in addition to existing company policy?
Thanks, Chairman. That's a good question. The new sick leave is specific to this situation that we are dealing with. So it is in addition to the sick leave that a company might have as a policy. So this is in addition to the company offered sick leave. Back to you.
Great, thanks. We had a couple of questions about immigration as well. I read somewhere that the USCIS has relaxed their signature requirements. Can you talk a little bit about that? Prema, sorry.
Sure. Sorry, I thought I was on mute. Yes, USCIS has relaxed the signature requirements. We are now able to use electronic signatures, not the e-sign, but the soft copy of the actual signature pages to file with our petitions. And that's a big relief, as you can imagine, because most of us are working from home and it's kind of difficult to coordinate all this, but we are able to do that because of some of these relaxed laws from USCIS. Back to you.
Great, thanks, Prema.
Oh, one more thing I just wanted to mention that while we are discussing all these employment law related issues, it's important for us to remember the immigration complications or implications related to H&L employees and green card processing. So our immigration webinars will be addressing these concerns in detail. So I would really urge all the people on this webinar, as well as anyone else that you know, to attend these webinars so that you can get more detailed information.
Yeah, it's I attended the last one on both of them on Wednesday and Friday, the accounting and the immigration one. Very informative and very relevant. So in terms of, while we have you, Prema, tell us kind of in the New York area how things are going, any updates in terms of you know, how the local government's treating the pandemic there, and what have your clients been telling you?
As you all know, New York, New Jersey has been affected the most so far. So needless to say, most of the businesses are closed, and people are working from home more than ever. The state, both states have enacted similar laws in addition to what the federal government is offering. There are specific laws that one can make use of in terms of either for employees or business purposes itself. So I would urge anyone interested to reach out to us, and we can give you more information specific to your business.
Great, thanks. Sasha, I think we've got a question.
Mukta Dar, feel free to speak and ask your question.
I thought I typed and sent it anyways. Thank you for allowing me to ask the question. We as a company have a lot of people on H&L visas, and some of them unfortunately may be getting relieved of their services. They're working on site with clients, and some of our clients are probably likely to withdraw for a period of time, for some period of time at least. They've all gone on a pause for some reason. So is there a way that we can have these employees also move on a furlough, or possibly subject them to any salary cuts?
That's a great question. So my understanding of that is that the H1 employees are not eligible for unemployment or to be put on furlough. They do have to get paid. I'm going to just ask Prema to elaborate that on that a little bit further, please.
Sure, you are right, Jamin. H-1B employees cannot be put on furlough or laid off because technically they're not available for work if because of the nature of the H-1B type of visa. So unfortunately, that's not an option available. But I'm sure, you know, there are other ways that you can address it in terms of a business necessity. And I'd urge you to reach out to one of our immigration specialists to discuss this.
Thanks, Prema. I got a similar question to it earlier today before this webinar. One of our clients wanted to put a H1, a full-time person on part-time. And I think I passed them along as well. So if you have specific questions that we could look into, we're happy to do that. Min, do you mind telling us what's going on in LA in terms of your clients and what the outlook is there?
Yeah, many of our clients are allowing their employees to work from home. They're trying to preserve jobs as much as they could. They are trying to get loans, FBA loans for the payroll protection, but that's difficult because there's a lot of the banks aren't qualified to give out those loans yet. So they're doing everything they can. There are talks that some of the employees may be furloughed or laid off, but that's okay because these employees can still get unemployment benefits.
Right. Right. So I think we have to remember that, you know, in general, in any state in the United States, it's at-will employment, right? And so everything that we've talked about today, it's very notice-based. As long as we're providing adequate notice to the employees and giving them an opportunity to figure out what's going on in their personal lives in terms of how it's going to affect their pay. That's where the federal government's stepping in, and so that's it's kind of a new found territory for everyone, because prior to this Paid Sick Leave Act, the government never required any private employers to provide paid sick leave. So this is uncharted territory for everyone. Are there any other questions that we have from any of the attendees, any of the panelists? So Chetna, actually, if you don't mind, I know that you've got a large client base, as most of us do in India as well. Can you tell us what you've been hearing from there in India with the there's a mandatory lockdown still in effect, and so how are the clients dealing with that there?
India also has come up with several packages to help the small business owners and the companies here. The lockdown is going to continue, unfortunately, for a few more months. It looks like where I am, it's going to be extended till June, and it's only getting worse here. So we can expect more of more work from home and more companies resorting to maybe layoffs. So yeah.
Yeah, it's tough. It's tough all around, unfortunately. I was told from one of our colleagues in the Santa Clara office that as soon as the ban was lifted in Wuhan, the first uptick was in divorces. And Brenda in our LA office, she does a lot of family law and custody cases and things. So what are some of the trends that you've seen in those custody or domestic violence cases? Is there an increase there?
Yes, Jamin, I've seen an increase in a lot of child custody exchange issues. They have a lot of issues. The parent who has the child and has to give the child for visitation feels like because of COVID-19, they should not send the child for visitation. But that is creating a lot of chaos. Police are getting involved a lot. Some are taking the position that it's okay to not send the child during COVID-19, the cops, and some are saying that we have to follow court orders. There is also an increase in domestic violence restraining orders, but there's some talk about how the victims are really scared right now and are scared to report domestic violence and are using code words at pharmacies. So yeah, definitely seeing a trend in child custody disputes, domestic violence restraining orders. I think staying at home during COVID-19 is adding to some sort of a stress between family members. So yeah, I can understand why this happened in Wuhan.
Right. And I remember you and I were discussing recently about a healthcare worker that lost her child due to an ex parte order. Can you tell us about that if you recall?
Yes, absolutely. So this was an order made by an Oklahoma judge where mom was a healthcare worker in a clinic and had custody of her children. Dad filed for an emergency order to take the kids away from her because she was exposed to COVID-19. And he also demonstrated incidents where she had been negligent with the children's health. So that is why the judge made an order, in the best interest of the children and gave the children to dad temporarily. And of course, this became a big hyped media issue, and the judge issued a gag order on both the parties. But we're yet to see such trends in Los Angeles.
Right, yeah. We've got a question again about salary cuts. Sasha, do you mind reading out the question?
I can handle it. The question is, how do we manage salary cuts? One of the panelists mentioned it cannot be based on what one is earning. Do we want to propose salary cuts for a brief period? Any guidelines on how to do so? Does it necessarily have to be uniform cuts throughout the organization? So when I spoke about salary cut, I did mention that you can cut salary based on one's earning. So you can say everybody who's making more than 100,000, we have to temporarily cut your salary by 5%. But you cannot make salary cut based on discriminatory reasons. You can't say for every employee who is a female, we're going to cut your salary by 5%. You can do this as long as you give them notice. Okay. It should be a formal legal letter saying because of COVID, because of the financial hardship, we're deciding to cut everyone's salary above X amount by X amount. Employment is at will. So it's up to the employee to say, okay, or they can terminate their relationship.
I would add.
Go ahead.
Go ahead, Hugo. Oh, thanks. Go ahead.
I was just going to say, you can literally do this on an individual basis. Like if you have a team of maybe like 15 people, you don't need to do across the board salary cuts. You can go to each individual. But yeah, as your team grows, you need a more scalable solution, something that kind of applies across the board to all people. If you are going to do an across the board salary cut, I recommend talking to an employment law attorney first to make sure that, again, it's in compliance with the new regulation.
All right. Thanks, Min. Thanks, Human. I would add just one more thing. Be careful if you've got H1 or H1 workforce. Make sure you're above the prevailing wage still. So we do a lot of, obviously we do a lot of employment law, we do a lot of litigation and corporate work and things. In terms of litigation cases, the courts, so I'm in Atlanta, like I mentioned, the courts here are essentially closed except for essential cases, and they've defined those separately in each particular jurisdiction. So what Brenda was mentioning about, restraining orders and things, those are obviously essential cases that the court is going to hear. I've done calls with judges and opposing counsels in the last couple of weeks for certain discovery disputes and things like that. So in terms of the Bay Area and how that's going there, Vikram, do you see an increase in litigation and cases related to COVID-19 once the ban is lifted for the courts as well?
Yes, thank you for that question, Jamin. Yeah, I strongly believe that the so-called ambulance chaser attorneys, they're going to be in full swing. The economy for them is going to be in full swing coming up in the next several months and the next several years, perhaps. I mean, I definitely think employers should be anticipating employment discrimination cases, workers' compensation cases, and maybe even cases related to negligence and wrongful death as well, because as we all know, unfortunately, people are passing away from this illness. So I definitely think all sorts of litigation related to COVID will be in full swing, and employers, you really can't anticipate where it's going to come from. It may be a workers' comp, it may be employment discrimination, it may be, like I said, suit for negligence and wrongful death. But in all cases, I highly recommend employers to take any claim they get by mail, email. Take it very seriously. Go consult your local attorney at your local Chugh office and get a proper consultation. Take every claim seriously. Do not put any claim, any email, any notification you receive on the side and take it for granted, because it could come back and hurt you down the road. So definitely anticipate increased litigation on this and be ready and prepared to respond to it by consulting with an attorney in your local jurisdiction.
Great, thanks, Vikram. There's one question that came through chat. Can someone who is getting a salary cut also apply for EDD? I think is that the
It is
California.
eligibility.
Okay, got it. So it's one of the California folks. Do you want to answer that?
Yeah, EDD is the unemployment claim. So now unemployment, you can get it based on a reduction in hours if it's significant enough, and it would be a partial unemployment benefit. So the answer is yes, it doesn't hurt to try and apply.
Great, thanks. Similarly here in Georgia, the you know, as we mentioned earlier in the call, there's $600 the federal government benefit, and the state of Georgia allows for partial unemployment for up to 6 weeks. So we've got partial unemployment going on for furloughed employees or you know, just folks that want to maintain their workforce, and they get the state and the federal benefits, which is pretty great for them. We've got
Hey, Jaimin, there is a question from Ravneet Singh.
yeah, let's do it.
So the question is, can I cut a bonus part of H-1B employee? So I'm guessing the question is, can the bonus part of the pay be cut for an H-1B employee? In short, if the bonus is in addition to the LCA salary, yes. But if it's a guaranteed bonus, which is included as part of the LCA required salary for the H-1B employee, then you cannot. Back to you.
Great, thanks. We've got a question from Amardeep Kaur. If you don't mind, great, thank you.
Hi, good morning, good afternoon, everybody. This is Amardeep here. So I had a question that if we have employees on per hour rate and on a salary basis, a fixed salary basis, if suppose the employees who are on a per hour rate are working for a particular customer, and that particular customer is having a shutdown for a week or 2 weeks, or is asking employees to work on for lesser hours of work, say 32 hours of work, and we proportionately pay them only for 32 hours. Will this be a discrimination because the employees on the fixed salary are still getting the full salary, but the employees on the per hour rate are getting lesser salary? Will this be a discrimination?
Hey, so this is Human Yavi from the Santa Clara office. First, thank you for the question. Short answer, no. Whether an individual is an hourly employee versus fixed salary is not like a categorization that's subject to discrimination. And as I think a couple folks on the panel have mentioned before, almost in every state, employment is at will. So this gives employers a lot of flexibility in terms of what they want to do with hours, with wages, with salaries. So that being said, you know, your client can, you know, reduce the hours that they're giving to that employee. They can reduce the salary. They can reduce the hourly rates. They can basically do anything, and then it's up to the employee whether they accept or not. It's at their will, right? So if they choose, you know what, this is too big of a cut for me, I feel like I'm worth more than this, they can go out into the market, search for another job. They can apply for unemployment benefits in the meantime. I mean, this is technically, you know, a demotion, which generally in California at least would qualify for unemployment benefits. So short answer, yeah, I mean, it's not going to be an issue.
Okay, thank you.
No problem.
Thanks, Human. And this is the last question. Are employees with less than 50 employees exempt from paid leave legislation, or is there a situation in which they need not necessarily extend new paid leave? So that's a good question. Right now, it's a maybe. As one of the speakers mentioned, that I think it's Chetna that mentioned, if the employer can show that there's going to be a hardship if they maintain the paid leave, then the Secretary of Labor is the one that's going to suggest whether they are exempt from that or not. It's still, it's part of the bill, but we don't know yet exactly how that's going to work. They're asking that the employers not send any information yet, but they'll give us the information once once they open that up. With that, I just want to thank everyone for joining. I really appreciate everyone's time. Chetna, Vikram, Brinda, Human, Min, Verduhi, and Prema. Thank you all for your time as well and the wonderful information. To all the attendees, again, thank you for your time and trusting us with this information. And as Navneet Chugh always mentions, this too shall pass. And I wish you all the best of luck in the upcoming weeks and months. And please reach out to us if you need anything.